introduction.
Take your time.
Yes. So my name is Zainab Malakuti, and I'm speaking to you from Tehran. So I have the great honor to moderate this session today. So as an introduction, since the establishment of the International Criminal Court, the US has developed a fluctuating relationship with the court. So first, the Clinton administration signed the Rome Statute
I'll go over all of it in my talk.
2000, on the same date that Iran signed the constituent instrument of the ICC. On the contrary, the opposition, Washington, you'll do it, okay, good. I just skip a little bit, and then, okay, so this cooperative relationship at the time of Trump administration. So today we just want to discuss with Professor Heller about the history of the relationship between US and ICC, and also in the time of Trump administration, and about future. So now Trump is apparently leaving White House, and it could put an end to the unilateralism endorsed by the Trump administration. At the background of this development, and at the time of a power change in the US, so we relationship with the court. So I'm pleased to introduce today's speaker to our audience, Professor Kevin John, National Law and Security at the University of Copenhagen, and Professor of Law at the Australian National University. He holds a PhD in law from Leiden University. So some of his books include the Nuremberg Military Tribunal and the Hidden Histories of War Crimes Trials. He co-edited the Oxford Handbook of International Criminal Law and is co-writing a book entitled The Vietnam War and the Transformation of International Law. Kevin also has been involved in the International Criminal Court's negotiations over the crime of aggression, worked as Human Rights Watch external. He is also a permanent member of the International Law blog, Opinion Jurist, which well known for all international law scholars, in particular our audience. So before I give the floor to Professor Heller, I would like to add that we will look forward to hearing from you during the question and answer section. So please feel free to share with us your comments and your question at the end of this presentation. So without any further point, I would like to welcome our guest, Professor Heller, and to deeply appreciate your presence and acceptance of our invitation. You will have the floor for the next 45 minutes. Thank you.
Well, first off, I want to thank the center for inviting me to give this talk. It's a great honor to do so. I wish I could be there.
Yes.
Sorry? I wish I could be there in person, but instead it's now late at night in Australia, where I currently am. I won't speak for 45 minutes. I should only speak for probably about 35, because I want to leave as much time as possible for questions about the presentation, about the court, or about any other aspect of international criminal law that the audience might be interested in. So just as a brief introduction, I don't intend to do anything kind of particularly groundbreaking in this lecture. In the time that I have, I simply want to do three things. First, I want to carefully trace the evolution of the US's relationship with the ICC from the court's earliest days to the Trump administration. Second, I want to try to explain why the Trump administration has been so unprecedentedly hostile to the court. And third and finally, I want to briefly speculate about how the US-ICC relationship might change under the new President Biden. So let's start with the pre-Trump era. The United States has always had a complicated relationship with the ICC. Although the Clinton administration actively participated in the drafting of the Rome Statute, the US was one of only 7 states to vote against the statute when it was adopted in 1998. And if you're interested, the others were China, Iraq, Israel, Libya, Qatar, and Yemen. And although President Clinton quite unexpectedly signed the Rome Statute in December 2000, not long before he left office, he refused to submit the treaty for Senate ratification on the ground of what he called its, quote, serious flaws. Now, the Bush administration was more overtly hostile to the ICC, at least at first. In May 2002, the administration informed the UN Secretary General that the US had no intention of ratifying the Rome Statute and was, in fact, unsigning the treaty in order to avoid having any obligations whatsoever toward the court. Now, later that year, Congress enacted the infamous American Service Members Protection Act, which essentially prohibited the US government from cooperating with ICC investigations in any significant way. At the same time, led by then Undersecretary of State John Bolton, a fairly notorious figure, the Bush administration engaged in a concerted campaign to coerce US allies and other states into guaranteeing that they would never transfer an American to the court, the so-called Article 98 agreements. Congress gave teeth to that campaign through what was called the Nethercutt Amendment, adopted in 2004. The Nethercutt Amendment authorized President Bush to withhold economic assistance to any state that ratified the Rome Statute, but refused to sign an Article 98 agreement with the US. I think it's important to emphasize that the Bush administration's opposition to the ICC softened considerably during the second term. In May 2005, the administration abstained from vetoing Security Council Resolution 1593, which referred the situation in Darfur to the court. The administration justified its abstention, which I think surprised most commentators, on the ground that the US and the ICC had a shared interest in combating impunity in Sudan. Indeed, the following year, John Bellinger III, the State Department's legal advisor, openly acknowledged in an interview with the Wall Street Journal that the court actually had a role to play in the overall system of international justice, a striking change of rhetoric from President Bush's own insistence during his re-election campaign that the ICC was, in fact, little more than what he called, quote, a body based in The Hague where unaccountable judges and prosecutors can pull our troops or diplomats up for trial. Moving forward, the Obama administration worked even more closely with the ICC. In 2009, it did not renew the Nethercutt Amendment. That same year, the administration dropped the US's longstanding opposition to even mentioning the ICC in UN resolutions, most notably when it supported Security Council Resolution 1888, which addressed sexual violence in armed conflict. Oh, no, I don't want to quite go there yet. In 2010, the US participated in the first ICC review conference in Kampala, Uganda, and then it attended the annual meeting of the court's Assembly of States Parties each year thereafter. In 2011, the US co-sponsored Security Council Resolution 1970, which referred the situation in Libya to the ICC, and perhaps most dramatically of all, when in March 2013, the notorious Congolese warlord Bosco Ntaganda turned himself into the American embassy in Rwanda, the US promptly surrendered him to the court to stand trial. So in short, the US's relationship with the ICC improved steadily from 2004 to 2016 under both Republican and Democratic administrations. Now that progress obviously ended with the election of one Donald Trump. The Trump administration has exhibited a level of hostility to the court that is truly unprecedented, going far beyond even the most hostile actions of the Bush administration during its first term. Now, the Trump administration's hostility toward the ICC is, first and foremost, a reaction to the Office of the Prosecutor's decision to investigate war crimes committed by Americans in Afghanistan and related states. On 14 November 2016, just 5 days after Trump's election, the OTP announced that it had found a reasonable basis to believe that members of the US military were responsible for the war crimes of torture and rape in Afghanistan, and that members of the CIA were responsible for similar crimes in Afghanistan and on the territory of other ICC member states, particularly Poland, Romania, and Lithuania. The OTP also concluded that the alleged war crimes were the product of US government policies to extract actionable intelligence from detainees, not simply the abuses of a few isolated individuals. Fast forward the following year, in November 2017, the OTP asked the ICC's pretrial chamber to formally authorize an investigation into the situation in Afghanistan. The Trump administration immediately attacked the OTP's authorization request. At first, it took a position quite similar to previous administrations, simply asserting that the court had no jurisdiction over nationals of states that have not ratified the Rome Statute. From there, however, the Trump administration's hostility toward the court only escalated. In September 2018, John Bolton, who is now Donald Trump's national security advisor, denounced the OTP's request to investigate the situation in Afghanistan as, quote, utterly unfounded and unjustifiable, and warned that the US would, quote, use any means necessary to protect our citizens and those of our allies from unjust prosecution by this illegitimate court. Now, also notably, Bolton, in that same speech, openly threatened retaliation against ICC staff involved in the Afghanistan investigation, as well as against any government that had the temerity to assist the OTP with its investigation. I'm not going to read this long quote to you, but it'll be up for a minute so you can read it yourself. On December 4th, Mike Pompeo, now Donald Trump's Secretary of State, reiterated and amplified Bolton's threats. Speaking at NATO headquarters, Secretary Pompeo promised that the US was taking, quote, real action to stop rogue international courts, like the International Criminal Court, from trampling on our sovereignty and all our freedoms. Pompeo then followed up that speech in March 2019, announcing that because the OTP had not withdrawn its request for an Afghanistan investigation, the Trump administration would deny court personnel the visas that they needed to enter the US. And you can see on the slide what Secretary Pompeo said. Now, he also added, foreshadowing later developments that we'll come to in a minute, that, quote, these visa restrictions will not be the end of our efforts. We are prepared to take additional steps, including economic sanctions, if the ICC does not change its course. Now, comments like these were fortunately quickly rejected by the international community. In the aftermath of Bolton's comments, for example, nearly a dozen ICC member states reaffirmed their commitment to the court, including the UK, France, and Germany. Moreover, the EU as a whole insisted that it would continue to strongly support the ICC and its work. Despite the international reaction, on 5 April 2019, the Trump administration revoked the visa that it had issued to Fatou Bensouda, the ICC's chief prosecutor. And then, 1 week later, the pretrial chamber rejected the OTP's request to authorize the Afghanistan investigation, to the surprise of essentially everyone, noting that, quote, subsequent changes within the relevant political landscape, both in Afghanistan and in key states, parties and non-parties to the statute, make it extremely difficult to gauge the prospects of securing meaningful cooperation from relevant authorities for the future. Now, although the pretrial chamber did not name the US as one of the relevant, quote, key states, there is no doubt that the Trump administration's threats weighed heavily on the judges. Indeed, President Trump himself described the decision as a major international victory for the US, while Secretary Pompeo openly attributed the rejection to US pressure, noting that the announcement immediately followed Bensouda's visa being denied. The OTP appealed the pretrial chamber's rejection of the authorization request, and not surprisingly, the Trump administration's, quote, major international victory proved short-lived. On 5 March 2020, the ICC's appeals chamber unanimously authorized the OTP to investigate any and all crimes committed on the territory of Afghanistan since May 2003, as well as other alleged crimes that have a nexus to the armed conflict in Afghanistan. The appeals chamber decision provoked the Trump administration into what can only be described as a declaration of war against the ICC. On March 17, Secretary Pompeo held an on-the-record press briefing during which he threatened to retaliate not only against 2 OTP employees, but even against the OTP employees' families. And you can read what he said on the slide. Even more dramatically, on June 11th, President Trump signed Executive Order 139238, entitled, quote, blocking property of certain persons associated with the International Criminal Court. The executive order, quite ridiculously, declares a national emergency on the ground that any attempt by the ICC to investigate, arrest, detain, or prosecute an American without US consent would constitute an unusual and extraordinary threat to the national security and foreign policy of the US. Section 1 then authorizes freezing the assets of any non-American determined by the Secretary of State to fall into one of four categories. You can see them on the slide, but basically anyone who works for the court or with the court. Section 4 of the executive order, in turn, denies a visa not only to any person who meets one of the criteria specified in Section 1, but also to their immediate family members, even if they have nothing to do with the Afghanistan investigation. Collective punishment, if there ever was collective punishment. The breadth and aggressiveness of the executive order is, I think, truly shocking. As a number of scholars have noted, the order would apply not only to non-Americans who work at the ICC, but also to foreign banks where the court has accounts, to foreign lawyers who submit amicus briefs to the court, and even, most dramatically, to victims of international crimes who testify in The Hague. In fact, I don't think it's an overstatement to say that if fully enforced, the executive order would make it effectively impossible for the ICC to function as an international organization. Not surprisingly, the international community responded to Trump's executive order with horror. On the 24th of June, 2020, a group of 67 ICC member states issued a joint statement denouncing the order, including traditional American allies such as Australia, Canada, France, Germany, and the United Kingdom. And you can see what this group of states said. And I think, if anything, the states are actually being generous. In the words of one leading scholar of the US executive, Trump's executive order is nothing less than, quote, a grotesque abuse of emergency powers. Unfortunately, such criticism has not deterred the Trump administration. Pursuant to the executive order, Fatou Bensouda's bank account with the UN Federal Credit Union has been frozen and her credit cards have been canceled. The administration has even frozen assets belonging to Bensouda's family who live in the United States. So, the Trump administration's unprecedented hostility toward the ICC raises a fairly obvious question. Why? Why does the Trump administration hate the ICC so much? Part of the answer, of course, is the very idea of the Afghanistan investigation. Now, we can discuss in the Q&A, if you're interested, whether the court has any hope of actually prosecuting Americans for crimes committed in Afghanistan, but there is no question that the investigation does pose a genuine threat, particularly to members of the CIA. We know that thanks to Chelsea Manning, who turned over what are known as the Afghan war logs to WikiLeaks in 2010. Those 90,000 activity reports concerning the Afghanistan conflict reveal an extraordinary amount of criminal wrongdoing by American nationals. There's no question those reports would be admissible in an ICC prosecution. Like all international criminal tribunals, the court takes a very inclusive approach to evidence, permitting the admission of any document that is relevant and necessary to ascertaining a defendant's criminal responsibility. Indeed, other international courts have relied on similar documents published by WikiLeaks, including the Grand Chamber of the European Court of Human Rights in El Masri versus Macedonia, and the Special Court for Sierra Leone in the Charles Taylor case. To be sure, the OTP has yet to name specific individuals it believes were tortured by the CIA, but it has identified locations in Afghanistan where it believes that those war crimes were committed, such as Bagram Air Force Base and the CIA's Black Site in Kabul, commonly referred to as the Dark Prison or Salt Pit. It has also identified at least 3 ICC member states, Poland, Romania, and Lithuania, on whose territory the CIA committed acts of torture. The Afghan war logs provide compelling evidence that the CIA detained and tortured numerous individuals in Afghanistan, Poland, Romania, and Lithuania, just as the OTP has alleged. And let me just give you 3 examples. First, Jamil El-Banna, a British resident and Jordanian citizen who was arrested by Gambian intelligence agents in November 2002. Albano was transferred to the dark prison and later to Bagram Air Force Base in Afghanistan. In the dark prison, he was imprisoned underground in isolation and darkness and tortured for 2 weeks. He was held in leg shackles 24 hours per day, starved, beaten, kicked, dragged along floors while shackled, and was unable to sleep due to the continuous screams from fellow detainees. Second, Ahmed Muhammad Haza al-Darbi, a Saudi Arabian citizen, was arrested in Azerbaijan in June 2002 by Azerbaijani officials. Al-Darbi was transferred to Bagram Air Base, where he was detained for about 8 months. At Bagram, he was kept in complete isolation for 2 weeks, hooded and interrogated for hours while being subjected to painful stress positions and subjected to extreme temperature, constant bright light, and loud music. Sometimes he was forced for hours to lean against a wall with his forehead pressed against the wall, his hands shackled behind his back, and his feet kept away from the wall so that his body weight rested on his forehead. After 2 weeks of isolation, he was placed in a cage with other detainees and hung on the cage door with his hands over his head. Third, Wessam al-Dimawi, a Jordanian national, was captured in Iran in December 2001. After being transferred to the CIA in early 2002, following an Iranian-Afghan prisoner exchange, al-Dimawi was held in a completely dark cell in the dark prison for 77 days. In the spring of 2003, he was transferred to Bagram Air Base, where he was held for 40 days and subjected to sleep deprivation, hung from the ceiling by his arms, threatened by dogs, made to watch torture videos, and subjected to sounds of electric sawing accompanied by cries of pain. I think it's safe to say that it's highly likely that the OTP will investigate the detention and torture of these 3 men. And if we had time and you had the interest, I could give you many more examples. Now, let me be clear here. Any American administration would forcefully oppose the ICC investigating CIA torture in Afghanistan, not just the Trump administration. We should never forget that President Obama refused to hold anyone in the Bush administration accountable for torture, infamously insisting, quote, "We must look forward, not backward," even as he acknowledged, quote, "We tortured some folks." Bipartisan opposition to Americans being investigated, however, cannot explain the Trump administration's hostility to the court, nor can Trump's general distaste for international organizations and the rule of law. So what then is the missing factor? Well, in my view, it's this. The ICC's investigation in Afghanistan does not simply threaten as of yet unnamed members of the CIA. It also threatens specific members of the Trump administration, both past and present, whose positions between 2003 and 2009 might have made them criminally responsible for war crimes as an accessory or on the basis of superior responsibility. Now, that might seem like a radical claim. So let me briefly discuss 4 Trump administration officials whose potential complicity in torture has been revealed, at least in part, by the Afghan war logs and WikiLeaks, and they're clockwise on the slide. The first is Gina Haspel, the CIA director since 2018. Haspel was in charge of a secret CIA black site in Thailand in 2002, known as Detention Site Green. The CIA transferred at least 3 detainees from Detention Site Green that year to face torture in Poland, Lithuania, and Romania: al-Nashiri, Abu Zubaydah, and Hambali. The OTP's authorization request specifically identifies war crimes committed in those 3 states as being connected to the conflict in Afghanistan. So, conceivably, Haspel has criminal responsibility for the subsequent torture. Second, Marshall Billingsley, Assistant Secretary for Terrorist Financing since 2017. In 2003, Billingsley was part of a Department of Defense working group that recommended the Secretary of State authorize the use of 35 different interrogation techniques, a number of which have long been considered to qualify as torture. Third, Lieutenant General Michael Flynn, the National Security Advisor for Trump in 2016. Flynn served as Director of Intelligence for Joint Task Force 180 in Afghanistan until July 2002. If you look at the OTP's authorization request, it specifically singles out JTF 180 for approving interrogation techniques that amounted to torture. And then fourth, and finally, perhaps most dramatically, Stephen G. Bradbury, General Counsel of the Department of Transportation since 2017. Bradbury authored the infamous 2005 Office of Legal Counsel memos that concluded none of the CIA's techniques in Afghanistan and elsewhere qualified as torture. So 4 Trump administration officials, 3 current, 1 past, who conceivably could end up being investigated and prosecuted by the ICC. It's also worth noting that all recent US administrations, not just the Trump administration, have gone to great lengths to undermine the ability of ICC member states to hold Americans accountable for crimes committed in Afghanistan and related states. Let me just give you 2 particularly striking examples of this, revealed again by WikiLeaks. First, in January 2007, German prosecutors issued arrest warrants for 13 suspected CIA agents in connection with Khaled al-Masri's extraordinary rendition. US diplomatic cables indicate that American officials exerted significant pressure on the German government not to pursue the extradition requests, which in fact they decided not to in September 2007. The year before, 2006, Spain's National Court began an investigation into allegations that the CIA used the Mallorca airport for extraordinary rendition flights. Diplomatic cables show that US State Department officials threatened prosecutors and government officials in Spain to end the investigation. Finally, let me just note, the repetition of such acts in the context of an actual ICC prosecution could qualify as an offense against the administration of justice. Article 71C of the Rome Statute prohibits, quote, corruptly influencing a witness, obstructing or interfering with the attendance or testimony of a witness, retaliating against a witness for giving testimony, or destroying, tampering with, or interfering with the collection of evidence. This offense applies to anyone who orders, solicits, induces, aids, and abets, or otherwise assists such interference. So a US government official who is involved in pressuring another government to refuse to comply with an ICC request for witness testimony in a specific case would almost certainly violate Article 71C, an offense that is punishable by a maximum of 5 years imprisonment. So what's next? Let me end this talk with a few words about what Biden's election as president might herald for the US ICC relationship. The first thing to note is that 2 things will definitely not change. First, the US will not ratify the Rome Statute under President Biden. Opposition to joining the ICC is, like overlooking torture, a genuinely bipartisan position. Second, I think it is quite safe to say that the US under President Biden will not cooperate with the court regarding the Afghanistan or Palestine situations. I am confident, however, that US opposition to the court will soften. In particular, I fully expect President Biden to rescind the executive order that Trump has used to sanction Fatou Bensouda. In general, I think that under Biden, we will see a return to the Obama-era relationship between the US and the ICC. President Biden was the vice president under Obama. We might call this a confluence of interest model. That means the Biden administration will work quietly with the court when their interests coincide, as they did when the US supported the Libya referral or when the US turned Ntaganda over to the court. So examples of places where you might see actual US ICC cooperation might be ICC efforts to prosecute Omar al-Bashir, the former president of Sudan, or perhaps to investigate Russian crimes in places like Ukraine and Georgia, 2 ongoing investigations. So that's all I have. That's my overview of the US ICC's turbulent relationship. I'm going to stop sharing the slides and we can have a discussion.
Thank you so much. Thank you very much, Dr. Heller. And I hope you all enjoyed this amazing presentation. I personally learned a lot about the work of the special procedure. Now, Professor Heller will answer some questions that were shared during the presentation. So if anyone have a question, please just write in the box of the question and answer. I have a question, so I'll ask my question and then other answers. So these unilateral sanctions that impose, yes, thank you. So these unilateral sanctions that imposed by the Trump administration, so these are unilateral. So I, my question is that to what extent you see these sanctions legitimate?
Well, legitimate or legal? um, I think they're clearly illegitimate. The US has no business using the kinds of sanctions that it has traditionally directed at war criminals to sanction an organization that is dedicated to stopping war criminals. To say that it's perverse to use sanctions against an international organization dedicated to international criminal law is an understatement. And it's a deeply sad development. I mean, we can't forget that the US has played really a leading, if not the most important role in the development of international criminal law over the past 75 years. There would have been no Nuremberg without the US. There would have been no Yugoslav tribunal. There would have been no Rwanda tribunal. There would have been no special court for Sierra Leone. So that's part of what makes the US's opposition to the ICC so unfortunate and so frustrating, because they've played such a leading role. And so for the Trump administration to actually go to such an extent to keep Fatou Bensouda out of the country, to freeze her bank accounts, to freeze her family's property, that is, I think, deeply perverse. So illegitimate, absolutely. Are the sanctions legal? That's an extremely difficult question. They are probably legal under international law insofar as the people who are sanctioned have some kind of genuine connection to the United States, insofar as they are just kind of trying to penalize anyone, anywhere who has any support for the ICC, that's probably pushing international law a little too far. Sanctions are not my area of expertise, so I don't want to give you a too detailed of an answer, but I would highly recommend a series of blog posts written by my friend Tom Rees on, I think it was Egil Talk or Just Security not too long ago, where he and his co-author go really carefully through the legality of these kinds of sanctions and secondary sanctions. So I would just highly recommend that. But so illegal, maybe. Illegitimate,
Yes.
absolutely.
Yes, thank you so much. Thank you. So our next question is from Rehana Haydari. So the question is that, is there a suitable international institution available to deal with the crimes of states like the United States? And is there such a concept as state crimes? And is genocide or aggression are state crimes?
Okay, well, that's actually 3 questions, but I can answer them. The answer to the first question, is there a suitable international institution available to deal with the crimes of a state like the United States? Well, answer sadly is no. There's no question that the ICC legitimately has jurisdiction over crimes in Afghanistan and in these various CIA black sites. There's no reason why the ICC can't bring charges against an American, whether a US serviceman or a CIA operative. But whether the ICC actually has the practical ability to get their hands on an American defendant, probably not. I would hate to see what the reaction of the Trump administration would be if, in fact, the ICC ever got its hands on an American. Probably would be worse than a Biden administration's response, but the Biden administration would not take kindly to the ICC prosecuting an American. So the sad reality is that, international law may be clear, but the ability to enforce international law against the most powerful state in the world is pretty minimal. I don't think we're going to ever see, or at least not in the near future, an actual ICC prosecution of an American. And frankly, there's no other institution out there that is really capable of such prosecutions. That's just the sad reality of the world that we live in. Now, is there such a concept as state crimes? Not really. I could give you a very long and professorial answer about this, but you probably wouldn't want to hear it. We don't have enough time anyway. But just very briefly, the International Law Commission did think about the idea of creating a category of state crimes, crimes where you would not just be prosecuting an individual, but you'd actually be prosecuting the state of which the individual was an agent. It almost made its way into the draft code of offenses, almost into the articles on state responsibility for internationally wrongful acts. But at the very end, they decided not to go down the road of state crimes and to limit criminal responsibility for international crimes to individuals. And what they replaced the idea of state crimes with is the idea of violations of a peremptory norm, very serious violations of international law for which there is state responsibility. So we can't really say as a legal matter that there's any such thing as a state crime. Now, of course, there are certain international crimes which are almost unimaginable without a state being involved. Genocide is a pretty good one. I mean, we can imagine an organized armed group like ISIS engaging in genocide, but normally genocide is committed by a state. You think about the Nazis, you think about the Hutu in Rwanda, you think about the Bosnian Serbs, etc. Aggression clearly is only capable of being committed by a state. A non-state actor can't commit an act of aggression. In fact, an element of the crime of aggression is a state act of aggression, but even so, it's not a state crime in the sense that you would hold the state criminally responsible for it. The crime of aggression is still about holding individuals within a state, those who direct or control the military or political apparatus of the state, responsible for aggression. So it sticks to the classic formula of international criminal law deals with individuals and not states. Although again, individual crimes have such a deep state component that we can almost not imagine them without the state being involved. Keep them coming.
Thank you. So our next question is that how much is it possible that some states which their nationals have been the victim of these human treatments use the compromissory clause in the relevant treaties to refer the case to ICJ? For example, the Torture Convention provision. So the question is here. If so, can this affect the hostile relationship of the US with the court?
Okay, well, I mean, first we need to clearly distinguish between the International Criminal Court, which is what I've been talking about, and the International Court of Justice, which isn't about individual criminal responsibility. It's about state responsibility for internationally wrongful acts. I'm not an ICJ expert, so I can't give you a particularly detailed answer. In general, the US does not accept the compulsory jurisdiction of the ICJ. That's a direct response to losing at the ICJ in the very famous Nicaragua case, where the US mined the Nicaraguan harbors to support the Contras. In general, the US will not participate in any ICJ proceeding. Is it possible that the US could have ratified a treaty that has one of these compromissory clauses? Probably. The Torture Convention might be a good one, and maybe there would be a way to create jurisdiction that way. Again, it's not really my area of expertise. And I do think that if there is a way to bring the US to the ICJ, that yes, the US would react quite badly to that possibility. And would be very unlikely to participate in any proceedings before the ICJ, just as it refuses to participate in any proceedings before the ICC. So the ICC is not the only international court that the US is opposed to. It's also very much opposed to the ICJ. Next question.
Yes, thank you so much. So the next question, so it's written, thanks for your informative presentation.
You can skip to the question.
So yeah, the question is that the appeals chamber prevented the pretrial chamber to assess the interest of the justice in the authorization stage. Do you see it reasonable to tutor in? Okay. So the next question is that, do you think that Israel will follow
should I
the
answer?
Trump example in imposing sanctions on the ICC staff, or will they avoid this move in order to keep enjoying Biden's and EU?
Okay, let me take those two questions. So with regard to judicial scrutiny over the selection of situations by the prosecutor,
Yes.
I don't think it's particularly reasonable to have too close of control, but we have to be careful here. So when the Office of the Prosecutor exercises its proprio motu power, when it decides of its own accord to open an investigation into a situation, such as in Afghanistan, it does have to go to the pretrial chamber and get authorization to open the investigation. It doesn't have to do that when a state refers a situation to the court. It doesn't have to do that when the Security Council refers a situation to the court, only when it's acting of its own accord. In that situation, obviously, the pretrial chamber does have to assess the evidence that the OTP presents to make sure that there is a reasonable basis to believe that crimes have been committed, that there are admissible cases, that the court has jurisdiction. But that should be a fairly minimal scrutiny. And I think we've seen the problems with over scrutiny by the pretrial chamber in the Afghanistan situation. Everyone I know, including me, was totally shocked when the pretrial chamber said the OTP couldn't investigate. Of course the OTP could investigate. It was precisely the kind of situation that the Rome Statute was designed for. So although the pretrial chamber does have to exercise some oversight, it should be fairly minimal. Now the flip side is when the Office of the Prosecutor refuses to open an investigation, which it always has the right to do. So it refuses to open an investigation into British crimes in Iraq, or it refuses to open an investigation into Israel's attack on the MV Mavi Marmara, a Comoros registered ship a number of years ago. I think it's extremely dangerous for the pretrial chamber to be able to second guess the prosecutor's decision not to open an investigation. I understand victims and NGOs being disappointed by that decision, but this to me really strikes at the heart of prosecutorial discretion. The OTP is an independent organ of the court. It should not be micromanaged by the judges. It should not be micromanaged by the registry. It shouldn't be micromanaged by everyone. And instead of constantly second guessing the OTP's decisions, well, states need to make sure that they elect a really good prosecutor and give the OTP the budget it needs to investigate accurately and assume that it will do a good job. So in general, I'm very skeptical of pretrial chamber management. Now to the Israel question, I don't think that Israel will follow the Trump example in imposing sanctions, frankly, because Israel is simply not a powerful enough state to be able to do so. I mean, the reason that the ICC can get away, or the US can get away with sanctions on the ICC is that they have the power to enforce it. You know, the dollar is extremely widely used currency. Almost all corporations and banks that might do business with the ICC have to be able to do business in the US, and they're very subject to pressure by the US. Israel's really not in the same ballpark as that. They might be able to, sanction those individuals and institutions that have some connection to Israel, but I would think that that's a fairly small sliver of the universe of people who work at the ICC or with the ICC. So I really don't see them doing that. It is, I also think that the election of Biden and the EU's traditional support for Palestine will have a tempering effect on Israel's actions. But even if Trump had been reelected, I'm not sure we would have seen Israel continuing or following down the path that the US had set out. So, next.
Thank you so much for your explanation. So the next question is about the universal jurisdiction. So what is your vision on the future of the ICC? Do you think the court will survive and actually be operative, or that universal jurisdiction will take more and more space?
Okay, that's an excellent question. It's like I planted Lavinia in the audience because I love answering this question. Will the court survive? Yes, the court will survive. I don't think, anytime in the next 4 or 5 decades, the ICC is literally going to disappear as an institution. Will the ICC ever kind of fulfill the expectations of the people who founded it, of the states that initially supported it? Probably not. The court has been around for 20 years now, and it's convicted a grand total of 4 people. It's convicted more people of offenses against the administration of justice than it's actually convicted of war crimes, crimes against humanity, or genocide. It's not that the ICC hasn't achieved anything, but it certainly has not achieved the kinds of results that it was expected to achieve. And we could have a very long discussion about why that is, but I think it's safe to say that unless there really is a dramatic reshuffling of the balance of power in the international community, unless all of a sudden states really decide that it's in their interest to finance the court and to throw their weight behind the court in terms of obtaining evidence and getting their hands on suspects, there really isn't any way that the court will achieve its goals. Will the court really ever be able to investigate and prosecute a sitting head of state? Probably not. Most of the prosecutions we have seen have been of rebel warlords or former heads of state, people who have been overthrown. That's the I suppose the exciting thing about Omar al-Bashir, that after 15 years of trying to prosecute him, his own people finally got tired of him, overthrew him, and now maybe, probably unlikely, but maybe he'll end up at the ICC. So it's a court that is largely going to deal with rebels, maybe the occasional terrorist, maybe the occasional former head of state that doesn't have a lot of powerful friends among the P5 on the Security Council. That isn't what the court was established to do. It was designed or intended to be a much more powerful court than that, and I don't think it's ever going to live up to those expectations. But that doesn't mean it will disappear, and it doesn't mean that what it does is nothing. We just have to temper our expectations of what it can accomplish. Now, in terms of universal jurisdiction, I mean, this is really my hobby horse. I am a huge fan of universal jurisdiction. Almost all states in the world, even ones that we would consider underdeveloped, and I hate that expression, but I'll use it just for the sake of answering this question. Almost every state in the world has a legal system that is more powerful and has greater capacity than the ICC. If international criminal law has a robust future, it is not going to be the ICC. It is not going to be the creation of new international criminal tribunals, because states just simply don't have the will to create them. It's going to be states asserting their right to prosecute international crimes under universal jurisdiction. It's so endlessly frustrating to me that you can't open a newspaper without seeing some scholar or activist calling for, an ad hoc tribunal for Syria or referring Syria to the ICC. Would those things be great? Sure. Not going to happen. What is happening right now in almost a dozen states is that Syrian crimes are being prosecuted by states via universal jurisdiction. Most of those prosecutions, admittedly, are in Western Europe, but there's even a case moving forward in Argentina. What we really need to do is encourage states to exercise universal jurisdiction. And again, not just states in the global north. We need to encourage states in the global south to assert universal jurisdiction over international crimes. And I think probably the precedent that is most hopeful for the future of international criminal law is nothing that happened at the ICC, nothing that happened in international tribunals, nothing that happened in Western European states. The most hopeful precedent is when Senegal prosecutes Hissène Habré, a former head of state, in an African court under universal jurisdiction. That idea, I think, would have been unimaginable 10 or 15 years. One African country prosecuting the head of state of another African country via universal jurisdiction. That's what the future should look like. And instead of spending all this time obsessing about the ICC, we need to spend more time helping states in the global south develop their judicial capacity, their prosecutorial ability, their investigative ability, and encouraging them to follow in the footsteps of the Senegal with Hissène Habré. So thank you. I'm very passionate about that particular issue.
Thank you so much. So more than 10 questions left. So because our time is limited, I just read the questions that related to today's webinar. So the next question is that will the relationship between the ICC and the US?
You have dropped out. Do you want me to, I can see the Q&A. Do you want me to handle the question?
Hello, can
Yeah, what I can see the questions. So do you want me just to go through? It's probably easier for me just to go through them.
me?
Sorry? Okay, let me go through some of these questions and answer them quickly. So one of the questions is, will the relations between the ICC and, sorry?
Sometimes happen. There is an internet connection.
Yeah. So let me, I can just, I'll just moderate my own questions because since we're running out of time. So will the relations between the ICC and the US change with the new prosecutor? Maybe. We don't know who the next prosecutor will be.
Please. Yes, please. Thank you.
If the next prosecutor, comes from the United Kingdom or comes from Canada, comes from kind of a traditional US ally.
Please,
maybe.
Thank you.
Most likely, whoever the next prosecutor is will inherit, a better situation because he or she will be dealing with with President Biden and not President Trump. But it's still not going to fundamentally change the dynamic between the U.S. and the ICC. Let me skip to will there be an aggression case in the court in the near future? Asked by one of the anonymous attendees. No, there will not be an aggression case in the court in the near future. There will almost certainly never be an aggression case at the ICC. And I don't have time to explain why. I've written extremely extensively about this issue. But basically, the jurisdictional requirements at the court for an aggression case are so incredibly narrow that it's very unlikely that any act of aggression will ever fall within the jurisdiction of the court. And again, you can Google aggression jurisdiction and Kevin John Heller, and you can find all of my posts on that. Let's see. So, so Mohammed, kind of raises the question about the US not ratifying the Rome Statute. It is, certainly not just the United States. There are many, many powerful states in the world that have refused to ratify the Rome Statute, in Russia, China, India, etc. It's unfortunate. I mean, obviously the court would function better if it had, global or near global ratification, but it isn't going to happen. And, to be fair, states are not under any obligation to ratify the Rome Statute. That doesn't mean that states that don't ratify the Rome Statute aren't subject to the court's jurisdiction, because in fact they are. When a non-state party like the US commits a crime on the territory of Afghanistan, a state party, the court does have the right to investigate. Now, I'm a fairly serious critic of the United States' foreign policy, but we do have to acknowledge that the US does not have any obligation to cooperate with the ICC. It has not ratified the Rome Statute, and the Rome Statute's cooperation provisions don't apply to it. Doesn't justify sanctioning members of the court. It doesn't justify the kind of ridiculously overheated rhetoric that we've seen from, the first term of the Bush administration and the Trump administration. But it is a reality of international law that states can choose whether to ratify treaties or not, ratify treaties, and the US has chosen not to ratify the Rome Statute. There is no way around that. You can't force the US or a Russia or a China or an India to cooperate with the court if it doesn't want to. The ICC simply has to find a way around that. And as I said before, I'm not very optimistic that the court is ever going to be able to take on one of the great powers and prosecute one of its nationals. What else we have? Let's see. Well, it's an interesting question about, does the ICC interact with other international criminal tribunals? Not really. Frankly, the only international tribunal that is still really fully going is the Special Tribunal for Lebanon, and the Special Tribunal for Lebanon doesn't do very much. Obviously, when the Rwanda Tribunal and the Yugoslav Tribunal were open, there was a closer relationship, but even there, the Rome Statute is a treaty. This is a treaty-based court. The ICC wasn't set up by the Security Council. It's a very different kind of court than the Yugoslav Tribunal or the Rwanda Tribunal or the Special Court for Sierra Leone. And so although certainly the judges at the ICC look to, say, the jurisprudence of other international criminal tribunals, they're not bound by it. They can go their own way. The Rome Statute often has a different approach to international criminal law than the ad hoc tribunals took. So it's really a very minimal impact that the other tribunals have had on it. Certainly they've helped develop international criminal law, but the judges at the ICC are both free to go their own way and often have gone their own way on important legal questions. See if there's any, I know we're running out of time, so this is the good question. As we've talked about, the ICC is about to elect its next prosecutor, and an anonymous attendee asks, how do I predict the prosecution in its new era? Conservative as the first prosecutor, or rather radical as the current one? I don't think I would describe Fatou Bensouda as particularly radical, but certainly Bensouda has kind of taken the court out of Africa. A very traditional criticism of the ICC was that all of its investigations were in Africa. Now we have the Afghanistan investigation, we have the Georgia investigation, we have the Ukraine investigation. She has taken us out of Africa, although not with a particularly strong amount of success. It's a really, really good question, and I don't know. Again, it really depends on who is elected. I think the next prosecutor is inheriting a very difficult situation. Inheriting an Afghanistan investigation that the US is very opposed to and will continue to be opposed to even under President Biden. The next prosecutor is inheriting the decision whether to open a formal investigation into the situation in Palestine, which implicates, the EU on one side and the US on the other. The next prosecutor is inheriting the Myanmar investigation, which is an investigation that is incredibly well-intentioned, one that everybody would love to see succeed, given the incredible violence that the Myanmar regime has committed against the Rohingya people. But it's not an investigation that is easy to carry off. There isn't an obvious way to successfully investigate the junta in Myanmar. And that situation is going to take up a lot of the next prosecutor's time. So I think pragmatically, the next prosecutor is likely to be relatively conservative in the sense that at least for the first few years, he or she is going to have to be dealing with a number of these investigations that have proven very difficult. And we could add the Georgia and Ukraine investigations to that list, where you're dealing with another huge power, Russia. The ICC's plate is quite full and is struggling to deal with all its investigations. And I foresee the next prosecutor really having to figure out what he or she is going to do about those investigations before he or she turns to new ones, conservative or radical. And maybe I should stop there because we're at time.
Yes, thank you so much. Thank you. So first of all, sorry for the interruption of the internet connection, and sometimes it happens. So thanks, Professor Heller, for helping me in this regard. Thank you again. Thank you. Thank you for answering the questions. And
let me just add that, my email is very easy to find. And if I didn't answer your question or you have other questions, feel free to email me.
It was a great pleasure to have you with us, and I hope we can organize more events with your presence. So this concludes
Okay, well, you've all disappeared. So thank you all so much for
thank you. So we hope you may send any further comments or question to our email.
Yeah. And you can pass them on to me, or you can write me directly.
Or directly to yes, sure. Thank you so much, everyone, and I hope you have a nice day or night.
Good night, everyone. Thank you.
See you later all. Bye.